Hey there, everyone. Josh Crowfoot here, Crowfoot Law Firm in Chattanooga, Tennessee. I'm a commercial real estate lawyer, and we're here on day 19 of Commercial Real Estate 101. Today, just wanted to say a few words about service contracts. Service contracts come into play with any commercial real estate that's being purchased where there is usually a business in play operating on the premises. I think of a hotel as a pretty key example. The service contracts are all of those vendors that have entered into a contract with the owner to do something for the property. Could be property management, could be maintenance, could be landscaping, could be a host of services. If you are the buyer and you're purchasing commercial real estate, you want to negotiate the ability to terminate those service contracts at will once you become the owner of the property. And furthermore, you want to negotiate that if there's any sort of termination fee involved with canceling those agreements, that you as the buyer are not on the hook for those fees that the seller is, and that if there's any sort of default provision that's triggered if the contracts are terminated, that the seller will be responsible for such fees. This is something that can get easily lost in the review of a commercial real estate purchase and sale agreement, but it's really important and can be a huge headache if it's overlooked. Typically, there'll be an exhibit to the agreement that has a list of all the service contracts, who they're with, how long the term of those contracts are, and whether or not they can terminate by their own accord, or if there is a specific endpoint, that exhibit will say when those contracts expire. Again, service contracts, not always relevant in every agreement, but in the ones that they are, you definitely want to pay attention to them and make sure that you have counsel that is negotiating those provisions for you on your behalf in a manner that benefits you. Hope you learned something.